Good afternoon. Happy Sunday. I know this is my third video of the day and I apologize about it. I've had a couple mentions, a couple questions about Louisiana Code of Criminal Procedure, Article 218.1, and I've already answered it in detail with Church of Cryonics. And now Day's Life is bringing it up, and he's bringing up other things as well. So I figured I would just answer some of these blatantly obvious questions in a video, hoping that I can get past people who don't understand what the F they're talking about and who draw conclusions based on what the F they don't know that they're talking about. And yeah. So it's amazing that my analysis matched that of a judge. It's just amazing that that happened. I mean, I guess me and the judge were not constitutional law scholars like my commenters are, but let's go into this. So first of all, this commenter thinks that there is hearsay, and that's what the police are operating under. And just so you know, there are various definitions for hearsay. Each state most likely has one. The Federal Rules of Evidence contains one. But generally speaking, it's an out-of-court statement made by a declarant, out of court, offered in court for the truth of the matter asserted in the statement. So a simple kind of example would be if person A is on the stand and the lawyer asks person A, do you know who committed the crime? Person A says, yes, person C committed the crime. And the lawyer says, well, how do you know person C committed the crime? And person A says, because person B said that he saw person A commit the crime. That's most likely hearsay. Now, if you get person B up on the stand and the lawyer says, okay, person B, do you know who committed the crime? Person B says, yes. All right, who committed the crime? Person C committed the crime. Well, how do you know person C committed the crime? Because I saw person C commit the crime. Is that hearsay? No, that's not hearsay. Now, again, also remember that hearsay is something that happens in court. It's an out-of-court statement made by a declarant that's offered in court for the truth of the matter asserted in that statement. So if you're not in court, there is not hearsay. And you're going to, maybe colloquially speaking, you could have hearsay out of court. But I'm a lawyer, and we're talking about law, and so hearsay is something that happens in court. If a witness or a complainant calls up 911 and says, I see somebody doing something that I think is a crime. They're doing X, Y, and Z. And the description is this and this and that. And then the dispatcher takes down that information and relays it to the police. Is that hearsay? Well, if we offered it in court, if the dispatcher goes into court and says, this is the person who's doing it, well, they don't have any firsthand knowledge. They're basing it off of what the person calling in said. So that would be hearsay. But the officer isn't in court. The officer's not a court. The officer can rely on that information to develop reasonable suspicion. And reasonable suspicion is based solely on what the officer knows at the time. It's solely based on the facts the officer knows at the time. Things he learns later, they don't come into play. His reasonable suspicion has to be based on what the officer knows, the information available to the officer at the time. Knows is a strong word. It's probably more believes, because, witnesses can be wrong. So if the officer gets a call that says someone who matched Travis Hines' description was doing things that are bizarre, trying to get into areas of the library that you can't get into, and bringing in 3 bags of equipment, setting up recording equipment in the library, the officer can respond to that and might even have confirmed. I don't know. Maybe he did, maybe he didn't. But even just having that information, when he gets there and he sees confirmation, here's a guy who matches the description. Here's all the recording equipment, matches the information that I received. Here's the 3 bags of equipment, matches the information. Does the officer have reasonable suspicion? I would suggest to you that yes, the officer has reasonable suspicion at that point. And a judge found that there was reasonable suspicion at that point. So it's not hearsay. I'm sorry. I've moved past. So does it give the police reasonable suspicion to detain an ID? Again, that's based on the hearsay thing. Hearsay is something that's being done in court. The officers aren't acting in court. And it says, and for Natchitoches, you didn't even look at the facts, but read some local news article. Okay. But that's what the officers knew, right? That's what the officers believed they knew. I'm disappointed in you as a lawyer. Well, I'm going to struggle to get over that. Why don't you watch the facts of what transpired before the cops showed up in Natchitoches, like you said? Well, first of all, I looked for the video and I didn't find it. Second of all, it doesn't really matter. The officers weren't there before the officers showed up. And so the officers' reasonable suspicion wouldn't be based on things that happened before they showed up. It would be based on the information that the librarians told the police, because the librarians were there. And if the librarians were wrong, then awesome, right? That's something that gets developed at trial. But the question of whether or not the police had reasonable suspicion is based on what the officers know or the information they have at the time. The video is available, all caps, there you go. Plus, even if, when was Travis lawfully detained for the investigation of a crime, as we know, all suspicion is not a crime. So, the officers can detain a suspect if they believe crime is afoot. They don't have to know what crime. And no, suspicion isn't a crime, but that's one of those cutesy little First Amendment auditor sayings that doesn't mean shit in the legal world. You don't hear attorneys walking around saying suspicion is not a crime, because we're not worried about proving a crime at the reasonable suspicion stage. They have to have reasonable suspicion crime is afoot. Illinois v. Wardlow. What crime? What crime did the officer suspect Wardlow of committing? Well, you might have had a gun in the bag. Maybe. He was in a high crime area. All they knew was crime was afoot. Well, all they believed was crime was afoot. And then it says the law states, Louisiana Code of Civil Procedure, Title V. I don't know where he got Title V from. The Code of... Oh, that's civil. Code of Criminal Procedure. See, I don't see any titles, but there is 218.1. Close that out. Advice of reasons for arrest or detention of rights. When any person has been blah, 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 right? He should be fully advised. When he's been detained, he should be fully advised of the reason for his arrest or detention. And that's this language. This language is identical to the Louisiana Constitution, Article 1, Section 13, this highlighted section here. So if you're dealing with this, you're dealing with this. This is from the 1974 Constitution. This was added by the 1974 Louisiana Congress or Assembly or whatever they call them. And it went into effect on January 1st, 1975. So, what about that? Well, first of all, what happens if they don't? What anywhere in the Code of Criminal Procedure, what is the effect of officers not complying with this? Well, the effect of officers not complying with this is that any statements that are made by the defendant would be suppressed, may be suppressed. Depends on if he said them in something that approached custodial interrogation. Why do I say that? Well, because you have a series of Louisiana Supreme Court cases, Supreme Court of Louisiana, that state as much. So this first one is dealing with Miranda, and they go on to say, finally, it appears that, in fact, there was an intention by the convention, this is the Constitutional Convention of Louisiana, to go beyond Miranda and to require more of the state regarding the precise issue now under discussion. In Article 1, Section 13, the cautions are triggered and must be given, quote, when any person has been arrested or detained in connection with the investigation or commission of any offense, end quote. The use of detained, in addition to arrested, was intended to provide a narrow construction of the latter term. So detained was intended to apply a narrow construction to arrested. Now, why do they say that? Well, when your Miranda rights kick in, when you're either arrested or you're placed in a coercive position that is similar to being arrested. So the cops definitely have to read you your Miranda warning before they interrogate you. If they've arrested you, if they said you're under arrest and they clickety-clack on the handcuffs and they say, we'd like to ask you a few questions. You have to read the Miranda warning first. If they don't read you your Miranda warning, you're still under arrest. But the court may suppress any statement you give if they fail to give you your Miranda warning. It's the same thing for this. It's the same thing for this. If they don't advise you of the nature of your detention, any statements that you make may be suppressed. But again, they're going to look at the coercive nature of it. State versus Seeger is another Louisiana Supreme Court decision. In interpreting the meaning of detained, it's essential to keep in mind the reasons for the requirement. We're still talking about the same thing, Article 1, Section 13. That's this. In interpreting the meaning of detained, it's essential to keep in mind the reasons for the requirement that police inform citizens of their constitutional rights prior to interrogation. Central to the purpose of this requirement is the protection of the individual's rights against self-incrimination from the coercive potential of police interrogation. In the present case, we find particularly significant the fact that the defendant initiated the contact by volunteer, blah, blah, blah. Right? The facts of this case do not show that the defendant was detained within the meaning of Article 1, Section 13 at the time he answered the sheriff's initial questions. The sheriff in this particular case had started questioning on who owned what plane and etc. So, and then once he said, I didn't own the plane, but I was a crew member of the plane, then all of a sudden things got real. And you can also see in State of Louisiana versus Palmer, a 2009 Supreme Court of Louisiana decision that this is footnote 3. In this case, again, they're talking about Miranda issues. And in footnote 3, they address the Louisiana Constitution, Article 1, Section 13, as well as the Louisiana Code of Criminal Procedure, Article 218.1. Defendant argues that before obtaining the signature on the consent form, the officers did not comply with Louisiana Constitution Article 1, Section 13, that provides that when any person has been arrested or detained in connection with the investigation or commission of any offense, he shall be fully advised of the reason for his arrest or detention, his right to remain silent, his right against self-incrimination, his right to the assistance of counsel, and, if indigent, his right to the court-appointed counsel. The court has observed that in Article 1, Section 13, the framers intended to adopt the Miranda v. Arizona edicts full-blown and unfettered. The use of detained in addition to arrested was intended to prevent a narrow construction of the latter term. In the defendant's view, the absence of Miranda warning tainted his consent and thereby required the suppression of evidence derived from the counsel. We do not revisit here the question of whether Article 1, Section 13 was intended to apply more broadly in the context of investigatory stops, yada, yada, because the defendant's consent to the search of his vehicle is non-commutative, blah, blah, blah. So this might be a good argument if Travis Hines had made a statement that they were intending to use against him when they were demanding his ID. But they did not. And so what happens? What is the end result of them not advising him of the nature of the detention? Well, nothing. But they did. But they did advise him of the nature of his detention. They said they were responding to a suspicious person complaint. Now, that doesn't mean they have to go into the nitty-gritty and start arguing the facts. They told him what they were detaining him for. A suspicious person complaint. They don't have to prove to Travis Hines that he was, in fact, a suspicious person and what specific crime he could eventually get arrested for. Because remember, the purpose of a reasonable suspicion Terry stop is an investigative stop. It gives the officers an opportunity to investigate the person to develop probable cause. Now, I'm not saying that I believe that it should be constitutional for cops to do investigative stops based on reasonable suspicion, but that's what the Supreme Court has allowed, and that's what the Supreme Court of Louisiana has interpreted Article 218.1 and Article 1, Section 13 to be. So I don't really think anything else is worth responding to. I hope that you guys understood that. I know it sucks, and I know you don't want Travis Hines to have been lawfully detained, and I know you don't want him to have I know you want him to not have had to ID, but unfortunately, in Louisiana, that's the state of the law. So if you live in Louisiana and you don't like it, I don't know, talk to your state assembly person or whatever, state representative. Maybe they can figure that out for you. Thanks for watching. Have a great day.